Chapter 1, Introduction to Human Rights Law. 1.1 Nature and Definition of Human Rights. Human rights are a special sort of inalienable moral entitlement. They attach to all persons equally, by virtue of their humanity, irrespective of race, nationality, or membership of any particular social group. Human rights belong to an individual as a consequence of being human. The term came into wide use after World War II, replacing the earlier phrase, natural rights, which had been associated with the Greco-Roman concept of natural law since the end of the Middle Ages. As understood today, human rights refer to a wide variety of values and capabilities reflecting the diversity of human circumstances and history. They are conceived of as universal. Universality of human rights is contractual, applying to all human beings everywhere, and is fundamental, referring to essential or basic human needs. The concept of human rights is based on the belief that every human being is entitled to enjoy his rights without discrimination. Human rights differ from other rights in two respects. Firstly, they are characterized by being inherent in all human beings by virtue of their humanity alone. They do not have, e.g., to be purchased or to be granted. Inalienable, within qualified legal boundaries, and equally applicable to all. Secondly, the main duties deriving from human rights fall on states and their authorities or agents, not on individuals. One important implication of these characteristics is that human rights must themselves be protected by law, the rule of law. Furthermore, any disputes about these rights should be submitted for adjudication through a competent, impartial and independent tribunal, applying procedures which ensure full equality and fairness to all the parties, and determining the question in accordance with clear, specific and pre-existing laws, known to the public and openly declared. Furthermore, any disputes about these rights should be submitted for adjudication through a competent, impartial and independent tribunal, applying procedures which ensure full equality and fairness to all the parties, and determining the question in accordance with clear, specific and pre-existing laws, known to the public and openly declared. 2. The idea of basic rights originated from the need to protect the individual against the arbitrary use of state power. Attention was therefore initially focused on those rights which oblige governments to refrain from certain actions. Human rights in this category are generally referred to as fundamental freedoms. As human rights are viewed as a precondition for leading a dignified human existence, they serve as a guide and touchstone for legislation. The specific nature of human rights, as an essential precondition for human development, implies that they can have a bearing on relations both between the individual and the state, and between individuals themselves. The individual-state relationship is known as the vertical effect of human rights. Vertical location has not elaborated to be clear for the students. While the primary purpose of human rights is to establish rules for relations between the individual and the state, several of these rights can also have implications for relations among individuals. This so-called horizontal effect implies, among other things, that a government not only has an obligation to refrain from violating human rights but also has a duty to protect the individual from infringements by other individuals. The right to life thus means that the government must strive to protect people against homicide by their fellow human beings. 1.2 Historical development. 1.2.1 Pre-World War II developments. The origins of human rights may be found both in Greek philosophy and the various world religions. In the Age of Enlightenment, 18th century, the concept of human rights emerged as an explicit category. Man, woman came to be seen as an autonomous individual, endowed by nature with certain inalienable fundamental rights that could be invoked against a government and should be safeguarded by it. Human rights were henceforth seen as elementary preconditions for an existence worthy of human dignity. Before this period, several charters codifying rights and freedoms had been drawn up, constituting important steps towards the idea of human rights. The first were the Magna Charta Libertatum of 1215, the Golden Bull of Hungary, 1222, the Danish Erik Klipping's Handfasting of 1282, the Joyeux Entree of 1356 and Brabant, Brussels, the Union of Utrecht. The first were the Magna Charta Libertatum of 1215, the Golden Bull of Hungary, 1222, the Danish Erik Klipping's Handfasting of 1282, the Joyeux Entree of 1356 and Brabant, Brussels, the Union of Utrecht 3. Of 1579, the Netherlands, and the English Bill of Rights of 1689. These documents specified rights, which could be claimed in the light of particular circumstances, e.g. threats to the freedom of religion, but they did not yet contain an all-embracing philosophical concept of individual liberty. Freedoms were often seen as rights conferred upon individuals or groups by virtue of their rank or status. In the centuries after the Middle Ages, the concept of liberty became gradually separated from status and came to be seen not as a privilege but as a right of all human beings. Spanish theologists and jurists played a prominent role in this context. Among the former, the work of Francisco de Vitoria (1486–1546) and Bartolomé de las Casas (1474–1566) should be highlighted. These two men laid the doctrinal foundation for the recognition of freedom and dignity of all humans by defending the personal rights of the indigenous peoples inhabiting the territories colonized by the Spanish crown. The Enlightenment was decisive in the development of human rights concepts. The ideas of Hugo Grotius (1583–1645), one of the fathers of modern international law, of Samuel von Pufendorf (1632–1694), and of John Locke (1632–1704), attracted much interest in Europe in the 18th century. Locke, for instance, developed a comprehensive concept of natural rights, his list of rights consisting of life, liberty and property. Jean-Jacques Rousseau (1712–1778) elaborated the concept under which the sovereign derived his powers and the citizens their rights from a social contract. The term human rights appeared for the first time in the French Déclaration des droits de l'homme et du citoyen, 1789. The people of the British colonies in North America took the human rights theories to heart. The American Declaration of Independence of the 4th of July 1776 was based on the assumption that all human beings are equal. It also referred to certain inalienable rights, such as the right to life, liberty and the pursuit of happiness. These ideas were also reflected in the Bill of Rights, which was promulgated by the state of Virginia in the same year. The provisions of the Declaration of Independence were adopted by other American states, but they also found their way into the Bill of Rights of the American Constitution. The French Déclaration des droits de l'homme et du citoyen of 1789, as well as the French Declaration of 1793, reflected the emerging international. The French Déclaration des droits de l'homme et du citoyen of 1789, as well as the French Declaration of 1793, reflected the emerging international. 4. Theory of universal rights. Both the American and French declarations were intended as systematic enumerations of these rights. The classic rights of the 18th and 19th centuries related to the freedom of the individual. Even at that time, however, some people believed that citizens had a right to demand that the government endeavor to improve their living conditions. Taking into account the principle of equality as contained in the French Declaration of 1789, several constitutions drafted in Europe around 1800 not only contained classic rights but also included articles which assigned responsibilities to the government in the fields of employment, welfare, public health, and education. Social rights of this kind were also expressly included in the Mexican Constitution of 1917, the Constitution of the Soviet Union of 1918, and the German Constitution of 1919. In the 19th century, there were frequent interstate disputes in connection with the protection of the rights of minorities in Europe. These conflicts led to several humanitarian interventions and called for international protection arrangements. One of the first such arrangements was the Treaty of Berlin of 1878. The need for international standards on human rights was first felt at the end of the 19th century, when the industrial countries began to introduce labor legislation. This legislation, which raised the cost of labor, had the effect of worsening their competitive position in relation to countries that had no labor laws. Economic necessity forced the states to consult each other. It was as a result of this that the first conventions were formulated in which states committed themselves vis-a-vis other states in regard to their own citizens. The Bernline Convention of 1906, which prohibited night shift work by women, can be seen as the first multilateral convention meant to safeguard social rights. Many more labor conventions were later drawn up by the International Labor Organization, ILO, which is founded in 1919. Remarkable as it may seem, therefore, while the classic human rights had been acknowledged long before social rights, the latter were first embodied in international regulations. 5. 1.2.3. Post-World War II developments. The atrocities of World War II put an end to the traditional view that states have full liberty to decide the treatment of their own citizens. The signing of the Charter of the United Nations, UN, on the 26th of June 1945 brought human rights within the sphere of international law. In particular, all UN members agreed to take measures. Are there really such large number of articles in UN Charter which deals with human rights protection? To protect human rights. The Charter contains a number of articles specifically referring to human rights. Less than 2 years later, the UN Commission on Human Rights, UNCHR, which was established early in 1946, submitted a draft Universal Declaration of Human Rights, UDHR. The UN General Assembly, UNGA, adopted the declaration in Paris on the 10th of December 1948. This day was later designated Human Rights Day. During the 1950s and 1960s, more and more countries joined the UN. Upon joining the UN, they formally accepted the obligations contained in the UN Charter, and in doing so subscribed to the principles and ideals laid down in the UDHR. This commitment was made explicit in the Proclamation of Tehran, 1968, which was adopted during the First World Conference on Human Rights, and repeated in the Vienna Declaration and Program of Action, which was adopted during the Second World Conference on Human Rights, 1993. Since the 1950s, the UDHR has been backed up by a large number of international conventions. The most significant of these conventions are the International Covenant on Civil and Political Rights, ICCPR, and the International Covenant on Economic, Social and Cultural Rights, ICESCR. These two covenants, together with the UDHR, form the International Bill of Human Rights. At the same time, many supervisory mechanisms have been created, including those responsible for monitoring compliance with the two covenants. Human rights have also been receiving more and more attention at the regional level. For example, in the European, the Inter-American and the African context, standards in supervisory. For example, in the European, the Inter-American and the African context, standards in supervisory 6. Mechanisms have been developed have already had a significant impact on human rights compliance in the respective continents, and promise to contribute to compliance in the future. 1.3 Theories of Human Rights Justification. The justification of a right refers to how we argue for its existence, what philosophical assumptions and theories we use to defend and define the right. Politicians, states and people do not necessarily use any explicit philosophical theory to support their views, or to explain why they believe in certain laws or basic rights, but they inevitably have some type of theory. Also, the nature of public policy is compromise and mishmash. Usually, no one philosophical theory wins out. Instead, policies reflect compromises between different theories. 2.2.1 Classification of human rights. The term, human rights, is used to denote a broad spectrum of rights ranging from the right to life to the right to a cultural identity. They involve all elementary preconditions for a dignified human existence. These rights can be ordered and specified in different ways. At the international level, a distinction has sometimes been made between civil and political rights, on the one hand, and economic, social and cultural rights on the other. This section clarifies this distinction. Since other classifications are also used, these will likewise be reviewed, without claiming, however, that these categorizations reflect an international consensus. It is also clear that the various categorizations overlap to a considerable extent. Although human rights have been classified in a number of different manners, it is important to note that international human rights law stresses that all human rights are universal, indivisible and interrelated, e.g. Vienna Declaration and Program of Action, 1993, para. 5. The indivisibility of human rights implies that no right is more important than any other. The indivisibility of human rights implies that no right is more important than any other. 7. I. Classic and social rights. One classification used is the division between classic and social rights. Quote, classic rights are often seen to require the non-intervention of the state, negative obligation, and social rights, as requiring active intervention on the part of the state. Classifying human rights in terms of negative and positive obligations may have its own defects, for a certain right may involve both negative and positive obligations for its effective realization. In other words, classic rights entail an obligation for the state to refrain from certain actions, while social rights oblige it to provide certain guarantees. Lawyers often describe classic rights in terms of a duty to achieve a given result, obligation of result, and social rights in terms of a duty to provide the means, obligations of conduct. The evolution of international law, however, has led to this distinction between classic and social rights has become increasingly awkward. Classic rights, such as civil and political rights, often require considerable investment by the state. The state does not merely have the obligation to respect these rights, but must also guarantee that people can effectively enjoy them. Hence, the right to a fair trial, for instance, requires well-trained judges, prosecutors, lawyers and police officers, as well as administrative support. Another example is the organization of elections, which also entails high costs. On the other hand, most social rights contain elements that require the state to abstain from interfering with the individual's exercise of the right. As several commentators note, the right to food includes the right for everyone to procure their own food supply without interference. The right to housing implies the right not to be a victim of forced eviction. The right to work encompasses the individual's right to choose his/her own work and also requires the state not to hinder a person from working and to abstain from measures that would increase unemployment. The right to education implies the freedom to establish and direct educational establishments, and the right to the highest attainable standard of health implies the obligation not to interfere with the provision of health care. In sum, the differentiation of classic rights from social rights does not reflect the nature of the obligations under each set of rights. 8. E. Civil, political, economic, social and cultural rights. Civil rights. The term, civil rights, is often used with reference to the rights set out in the first 18 articles of the UDHR, almost all of which are also set out as binding treaty norms in the ICCPR. From this group, a further set of physical integrity rights has been identified, which concern the right to life, liberty and security of the person, and which offer protection from physical violence against the person, torture and inhuman treatment, arbitrary arrest, detention, exile, slavery and servitude, interference with one's privacy and right of ownership, restriction of one's freedom of movement, and the freedom of thought, conscience and religion. The difference between basic rights, see below, and physical integrity rights lies in the fact that the former include economic and social rights but do not include rights such as protection of privacy and ownership. Although not strictly an integrity right, the right to equal treatment and protection in law certainly qualifies as a civil right. Moreover, this right plays an essential role in the realization of economic, social and cultural rights. Another group of civil rights is referred to under the collective term, due process rights. These pertain, among other things, to the right to a public hearing by an independent and impartial tribunal, the presumption of innocence, the ne bis in idem principle and legal assistance, see, e.g., Articles 9, 10, 14 and 15 of the ICCPR. Political rights. In general, political rights are those set out in Articles 19 to 21 of the UDHR and also codified in the ICCPR. They include freedom of expression, freedom of association and assembly, the right to take part in the government of one's country, and the right to vote and stand for election at genuine periodic elections held by secret ballot. See Articles 18, 19, 21, 22 and 25 of the ICCPR. In general, political rights are those set out in Articles 19 to 21 of the UDHR and also codified in the ICCPR. They include freedom of expression, freedom of association and assembly, the right to take part in the government of one's country, and the right to vote and stand for election at genuine periodic elections held by secret ballot. See Articles 18, 19, 21, 22 and 25 of the ICCPR. 9. Economic and social rights. The economic and social rights are listed in Articles 22 to 26 of the UDHR, and further developed and set out as binding treaty norms in the ICESCR. These rights provide the conditions necessary for prosperity and well-being. Economic rights refer, for example, to the right to property, the right to work, which one freely chooses or accepts, the right to a fair wage, a reasonable limitation of working hours, and trade union rights. Social rights are those rights necessary for an adequate standard of living, including rights to health, shelter, food, social care, and the right to education, Articles 6 to 14 of the ICESCR. Cultural rights. The UDHR lists cultural rights in Articles 27 and 28. These include the right to participate freely in the cultural life of the community, to share in scientific advancement, and the right to the protection of the moral and material interests resulting from any scientific, literary or artistic production of which one is the author. See also Article 15 of the ICESCR and Article 27 of the ICCPR. The alleged dichotomy between civil and political rights, and economic, social and cultural rights. Traditionally, it has been argued that there are fundamental differences between economic, social and cultural rights, and civil and political rights. These two categories of rights have been seen as two different concepts and their differences have been characterized as a dichotomy. According to this view, civil and political rights are considered to be expressed in a very precise language, imposing merely negative obligations which do not require resources for their implementation, and which, therefore, can be applied immediately. On the other hand, economic, social and cultural rights are considered to be expressed in vague terms, imposing only positive obligations conditional on the existence of resources and therefore involving a progressive realization. As a consequence of these alleged differences, it has been argued that civil and political rights are justiciable whereas economic, social and cultural rights are not. In other words, this view holds that only violations of civil and political rights can be adjudicated by judicial or similar bodies, while economic, social and cultural rights are, by their nature, non-justiciable. In other words, this view holds that only violations of civil and political rights can be adjudicated by judicial or similar bodies, while economic, social and cultural rights are, by their nature, non-justiciable. 10. Over the years, economic, social and cultural rights have been re-examined and their juridical validity and applicability have been increasingly stressed. During the last decade, we have witnessed the development of a large and growing body of case law of domestic courts concerning economic, social and cultural rights. This case law, at the national and international level, suggests a potential role for creative and sensitive decisions of judicial and quasi-judicial bodies with respect to these rights. E. Fundamental and basic rights. Fundamental rights are taken to mean such rights as the right to life and the inviolability of the person. Within the UN, extensive standards have been developed which, particularly since the 1960s, have been laid down in numerous conventions, declarations and resolutions, and which bring already recognized rights and matters of policy which affect human development into the sphere of human rights. Due to the concern that a broad definition of human rights may lead to the notion of violation of human rights, losing some of its significance has generated a need to distinguish a separate group within the broad category of human rights. Increasingly, the terms elementary, essential, core, and fundamental human rights are being used. Another approach is to distinguish a number of basic rights which should be given absolute priority in national and international policy. These include all the rights which concern people's primary material and non-material needs. If these are not provided, no human being can lead a dignified existence. Basic rights include the right to life, the right to a minimum level of security, the inviolability of the person, freedom from slavery and servitude, and freedom from torture, unlawful deprivation of liberty, discrimination and other acts which impinge on human dignity. They also include freedom of thought, conscience and religion, as well as the right to suitable nutrition, clothing, shelter and medical care, and other essentials crucial to physical and mental health. Mention should also be made of so-called participation rights. For instance, the right to participate in public life through elections, which is also a political right, see above, or to take part in cultural life. These participation rights are generally considered to belong to the category. These participation rights are generally considered to belong to the category 11. The fundamental rights being essential preconditions for the protection of all kinds of basic human rights. IV. Other classifications. Freedoms. Preconditions for a dignified human existence have often been described in terms of freedoms, e.g., freedom of movement, freedom from torture, and freedom from arbitrary arrest. United States President Franklin D. Roosevelt summarized these preconditions in his famous Four Freedoms speech to the United States Congress on the 26th of January 1941. Freedom of speech and expression. Freedom of belief, the right of every person to worship God in his own way. Freedom from want, economic understandings which will secure to every nation a healthy peacetime life for its inhabitants, and freedom from fear, worldwide reduction of armaments to such a point and in such a thorough fashion that no nation would be able to commit an act of physical aggression against any neighbor. Roosevelt implied that a dignified human existence requires not only protection from oppression and arbitrariness but also access to the primary necessities of life. Civil liberties. The concept of civil liberties is commonly known, particularly in the United States, where the American Civil Liberties Union, a non-governmental organization, has been active since the 1920s. Civil liberties refer primarily to those human rights which are laid down in the United States Constitution: freedom of religion, freedom of the press, freedom of expression, freedom of association and assembly, protection against interference with one's privacy, protection against torture, the right to a fair trial, all the rights of workers. This classification does not correspond to the distinction between civil and political rights. 12. Individual and collective rights. Although the fundamental purpose of human rights is the protection and development of the individual rights, some of these rights are exercised by people in groups, collective rights. Freedom of association and assembly, freedom of religion and, more especially, the freedom to form or join a trade union, fall into this category. The collective element is even more evident when human rights are linked specifically to a membership of a certain group, such as the right of members of ethnic and cultural minorities to preserve their own language and culture. One must make a distinction between two types of rights, which are usually called collective rights: individual rights enjoyed in association with others, and the rights of a collective. The most notable example of a collective human right is the right to self-determination, which is regarded as being vested in peoples rather than in individuals. See Articles 1 of the ICCPR and ICESCR. The recognition of the right to self-determination as a human right is grounded in the fact that it is seen as a necessary precondition for the development of the individual. It is generally accepted that collective rights may not infringe on universally accepted individual rights, such as the right to life and freedom from torture. First, second and third generation rights. The division of human rights into three generations was first proposed by Karel Vasek at the International Institute of Human Rights in Strasbourg. His division follows the principles of liberté, égalité and fraternité of the French Revolution. First generation rights are related to liberty and refer fundamentally to civil and political rights. The second generation rights are related to equality, including economic, social and cultural rights. Third generation or solidarity rights cover group and collective rights, which include, inter alia, the right to development, the right to peace and the right to a clean environment. The only third generation right which so far has been given an official human rights status, apart from the right to self-determination, which is of longer standing, is the right to development. See the Declaration on the Right to Development, adopted by the UNGA on the 4th of December 1986, and the 1993 Vienna Declaration and Program of Action, paragraph I-10. The Vienna Declaration confirms the right to development as a collective as well as an individual right. The Vienna Declaration confirms the right to development as a collective as well as an individual right. 13. Individuals being regarded as the primary subjects of development. Recently, the right to development has been given considerable attention in the activities of the High Commissioner for Human Rights. The EU and its member states also explicitly accept the right to development as part of the human rights concept. While the classification of rights into generations has the virtue of incorporating communal and collective rights, thereby overcoming the individualist moral theory in which human rights are grounded, it has been criticized for not being historically accurate and for establishing a sharp distinction between all human rights. It would be more interesting if how HT concepts of generations of tights as it adds with the Tehran Proclamation or the UDPA was described or explained. 2.3. Sources of human rights law. Since time immemorial, states and peoples have entered into formal relationships with each other. Over the ages, traditions have developed on how such relationships are conducted. These are the traditions that make up modern, international law. Like domestic law, international law covers a wide range of subjects such as security, diplomatic relations, trade, culture and human rights, but it differs from domestic legal systems in a number of important ways. In international law there is no single legislature, nor is there a single enforcing institution. Consequently, international law can only be established with the consent of states and is primarily dependent on self-enforcement by the same states. In cases of non-compliance there is no supranational institution, enforcement can only take place by means of individual or collective actions of other states. This consent, from which the rules of international law are derived, may be expressed in various ways. The obvious mode is an explicit treaty, imposing obligations on the states parties. Such treaty law constitutes a dominant part of modern international law. Besides treaties, other documents and agreements serve as guidelines for the behavior of states, although they may not be legally binding. Consent may also be inferred from established and consistent practice of states in conducting their relationships with each other. The sources of international law are. The sources of international law are 14. Many states commit to them to different degrees. The internationally accepted classification of sources of international law is formulated in Article 38 of the Statute of the International Court of Justice. Forming one of the regimes of international law, human rights law has the same source with the former. A. International conventions, whether general or particular. B. International custom, as evidence of general practice accepted as law. C. The general principles of law recognized by civilized nations. D. Subsidiary means for the determination of rules of law such as judicial decisions and teachings of the most highly qualified publicists. These sources will be analyzed below. A. International conventions. International treaties are contracts signed between states. They are legally binding and impose mutual obligations on the states that are party to any particular treaty, states parties. The main particularity of human rights treaties is that they impose obligations on states about the manner in which they treat all individuals within their jurisdiction. Even though the sources of international law are not hierarchical, treaties have some degree of primacy. Nowadays, more than 40 major international conventions for the protection of human rights have been adopted. International human rights treaties bear various titles, including covenant, convention, and protocol, but what they have in common are the explicit indication of states parties to be bound by their terms. Human rights treaties have been adopted at the universal level, within the framework of the United Nations and its specialized agencies, for instance, the ILO and UNESCO, as well as under the auspices of regional organizations, such as the Council of Europe (CO), the Organization of American States (OAS), and the African Union (O), formerly the Organization of African Unity (OAU). These organizations have greatly contributed to the codification of a comprehensive and consistent body of human rights law. These organizations have greatly contributed to the codification of a comprehensive and consistent body of human rights law. 15. I. Universal Conventions for the Protection of Human Rights. Human rights had already found expression in the Covenant of the League of Nations, which led, inter alia, to the creation of the International Labor Organization. At the San Francisco Conference in 1945, held to draft the Charter of the United Nations, a proposal to adopt a Declaration on the Essential Rights of Man was put forward but was not examined because it required more detailed consideration than was possible at the time. Nonetheless, the UN Charter clearly speaks of promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language or religion. Article 1, para. 3. The idea of promulgating an International Bill of Rights was developed immediately afterwards and led to the adoption in 1948 of the Universal Declaration of Human Rights, UDHR. The UDHR, adopted by a resolution of the United Nations General Assembly, UNGA, although not a treaty, is the earliest comprehensive human rights instrument adopted by the international community. On the same May that it adopted the Universal Declaration, the UNGA requested the UN Commission on Human Rights to prepare, as a matter of priority, a legally binding human rights convention. Wide differences in economic and social philosophies hampered efforts to achieve agreement on a single instrument, but in 1954 two draft conventions were completed and submitted to the UNGA for consideration. 12 years later, in 1966, the International Covenant on Economic, Social 21 and Cultural Rights, ICESCR, and the International Covenant on Civil and Political Rights, ICCPR, were adopted, as well as the first optional protocol to the ICCPR, which established an individual complaints procedure. Both covenants and the optional protocol entered into force in 1976. A second optional protocol to the ICCPR, on the abolition of the death penalty, was adopted in 1989 and entered into force in 1991. The International Bill of Human Rights consists of the Universal Declaration of Human Rights, the ICESCR, and the ICCPR and its two optional protocols. The International Bill of Rights is the basis for numerous conventions and national constitutions. 16. Besides the International Bill of Human Rights, a number of other instruments have been adopted under the auspices of the UN and other international agencies. They may be divided into three groups. A. Conventions elaborating on certain rights, inter alia. The Convention on the Prevention and Punishment of the Crime of Genocide, 1948, ILO 98 concerning the right to organize and to bargain collectively, 1949, the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, 1984, B. Conventions dealing with certain categories of persons who may need special protection, inter alia. the Convention relating to the status of refugees, 1951, and the 1967 Protocol thereto, the Convention on the Rights of the Child, 1989, optional protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflicts, 2000, optional protocol to the Convention on the Rights of the Child on the Sale of Children, Child Prostitution and Child Pornography, 2000, ILO 169 concerning indigenous and tribal peoples in independent countries, 1989, the International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, 2000, c. Conventions seeking to eliminate discrimination, ILO 111 concerning discrimination in respect of employment and occupation, 1958, UNESCO Convention against Discrimination in Education, 1960, the International Convention on the Elimination of All Forms of Racial Discrimination, 1965, International Convention on the Suppression and Punishment of the Crime of Apartheid, 1973, the Convention on the Elimination of All Forms of Discrimination Against Women, 1979, and its optional protocol, 2000. The Convention relating to the status of refugees, 1951, and the 1967 Protocol thereto, the Convention on the Rights of the Child, 1989, optional protocol to the Convention on the Rights of the Child on the Involvement of Children in Armed Conflicts, 2000, optional protocol to the Convention on the Rights of the Child on the Sale of Children, Child Prostitution and Child Pornography, 2000, ILO 169 concerning indigenous and tribal peoples in independent countries, 1989, the International Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, 2000, c. Conventions seeking to eliminate discrimination, ILO 111 concerning discrimination in respect of employment and occupation, 1958, UNESCO Convention against discrimination in education, 1960, the International Convention on the Elimination of All Forms of Racial Discrimination, 1965, International Convention on the Suppression and Punishment of the Crime of Apartheid, 1973, the Convention on the Elimination of All Forms of Discrimination Against Women, 1979, and its optional protocol, 2001-7. E. Regional Conventions for the Protection of Human Rights. The UN Charter encourages the adoption of regional instruments for the establishment of human rights obligations, many of which have been of crucial importance for the development of international human rights law. The Council of Europe adopted in 1950 the European Convention for the Protection of Human Rights and Fundamental Freedoms, supplemented by the European Social Charter in 1961, the European Convention for the Prevention of Torture and Inhuman or Degrading Treatment or Punishment in 1987, and the Framework Convention on National Minorities in 1994. The American Convention on Human Rights was adopted in 1969, under the auspices of the Organization of American States. This convention has been complemented by two protocols, the 1988 Protocol of San Salvador on economic, social, and cultural rights and the 1990 Protocol to abolish the death penalty. Other inter-American conventions include the Convention to Prevent and Punish Torture, 1985, the Convention on the Forced Disappearances of Persons, 1994, and the Convention on the Prevention, Punishment and Eradication of Violence Against Women, 1995. In 1981, the Organization of African Unity, now the African Union, adopted the African Charter on Human and People's Rights. Two protocols to the Charter have been adopted, the additional Protocol on the Establishment of the African Court on Human and People's Rights, 1998, and the Protocol on the Rights of Women in Africa, 2003. Other African instruments include the Convention governing the specific aspects of refugee problems in Africa, 1969, and the African Charter on the Rights and Welfare of the Child, 1990. B. International custom. Customary international law plays a crucial role in international human rights law. The statute of the International Court of Justice refers to general practice accepted as law. In order to become international customary law, the general practice needs to represent a broad consensus in terms of content and applicability, deriving from a sense that the practice is obligatory, opinio juris et necessitatis. Customary law is binding on all states, except those that may have objected to it during its formation, whether or not they have ratified any relevant treaty. Customary law is binding on all states, except those that may have objected to it during its formation, whether or not they have ratified any relevant treaty. 18. One of the important features of customary international law is that customary law may, under certain circumstances, lead to universal jurisdiction or application, so that any national court may hear extraterritorial claims brought under international law. In addition, there also exists a class of customary international law, jus cogens, or peremptory norms of general international law, which are norms accepted and recognized by the international community of states as a whole as norms from which no derogation is permitted. Under the Vienna Convention on the Law of Treaties, VCLT, any treaty which conflicts with a peremptory norm is void. Many scholars argue that some standards laid down in the Universal Declaration of Human Rights, which in formal terms is only a resolution of the UNGA and is such not legally binding, have become part of customary international law as a result of subsequent practice, therefore they would be binding upon all states. Within the realm of human rights law, the distinction between concepts of customary law, treaty law, and general principles of law are often unclear. The Human Rights Committee in its General Comment 24, 1994, has summed up the rights which can be assumed to belong to this part of international law which is binding on all states, irrespective of whether they have ratified relevant conventions, and to which no reservations are allowed. A state may not reserve the right to engage in slavery, to torture, to subject persons to cruel, inhuman or degrading treatment or punishment, to arbitrarily deprive persons of their lives, to arbitrarily arrest and detain persons, to deny freedom of thought, conscience and religion, to presume a person guilty unless he proves his innocence, to execute pregnant women and children, to permit the advocacy of national, racial or religious hatred, to deny to persons of marriageable age the right to marry, or to deny to minorities the right to enjoy their own culture, profess their own religion, or use their own language, and the right to a fair trial. Although this list is subject to debate and could possibly be extended with other rights not in the field of civil and political rights, for instance, genocide and large parts of the four Geneva Conventions on International Humanitarian Law, the committee underlines that there is a set of. Although this list is subject to debate and could possibly be extended with other rights not in the field of civil and political rights, for instance, genocide and large parts of the four Geneva Conventions on International Humanitarian Law, the committee underlines that there is a set of 19 human rights which de jure are beyond the politically oriented debate on the universality of human rights. C. General principles of law. In the application of both national and international law, general or guiding principles are used. In international law, they have been defined as logical propositions resulting from judicial reasoning on the basis of existing pieces of international law. At the international level, general principles of law occupy an important place in case law regarding human rights. A clear example is the principle of proportionality, which is important for human rights supervisory mechanisms in assessing whether interference with a human right may be justified. Why are general principles used? No legislation is able to provide answers to every question and to every possible situation that arises. Therefore, rules of law are principles that enable decision makers and members of the executive and judicial branches to decide on the issues before them are needed. General principles of law play two important roles. On the one hand, they provide guidelines for judges, in particular, in deciding in individual cases. On the other hand, they limit the discretionary power of judges and of members of the executive in their decisions in individual cases. D. Subsidiary means for the determination of rules of law. According to Article 38 of the Statute of the International Court of Justice, judicial decisions and the teachings of the most qualified publicists are subsidiary means for the determination of rules of law. Therefore, they are not, strictly speaking, formal sources, but they are regarded as evidence of the state of the law. As for the judicial decisions, Article 38 of the Statute of the International Court is not confined to international decisions, such as the judgments of the International Court of Justice, the Inter-American Court, the European Court and the future African Court on Human Rights. Decisions of national tribunals relating to human rights are also subsidiary sources of law. The writings of scholars contribute to the development and analysis of human rights law. Compared to the formal standard setting of international organs, the impact is indirect. Nevertheless, influential contributions have been made by scholars and experts working in human rights fora, for instance, in the UN Subcommission on the Promotion and Protection. Nevertheless, influential contributions have been made by scholars and experts working in human rights fora, for instance, in the UN Subcommission on the Promotion and Protection 20 of human rights, as well as by highly regarded NGOs, such as Amnesty International and the International Commission of Jurists. 21. Chapter 2, Human Rights System Sad Face, Substantive Rights, Institutions and Procedures. 2.1 The Universal System, the UN System 2.1.1. The Legal Framework A. The UN Charter adopted on the 26th of June 1945, the United Nations Charter was designed to establish the foundations of a new peaceful world order. Drawing lessons from the appalling atrocities of the Second World War, the Charter's primary aim was thus to save succeeding generation from the scourge of war, preamble, paragraph 2, and to ensure the maintenance of international peace and security. Within such broad and ambitious objectives, a respect for human rights and fundamental freedoms found its significant though ambivalent reflection. The Charter has demonstrated not only a move towards the lasting and stable internationalization of human rights, but it has also implied their contribution to ensuring the establishment of the peaceful, post-war world order. Under the Dumbarton-Oaks proposals for the United Nations of 1944, the four powers intended to have rather a general reference to human rights. Finally, during the San Francisco Conference, more extensive references to human rights were included in the Charter, albeit this compromise was achieved at the expense of less imperative formulations. Finally, the Charter refers to human rights in altogether 7 provisions of diversified content and character. Paragraph 3 of the Preamble, Article 1-3, Articles 55 and 56, Article 76, C, Article 13, 1b, Article 62-2 and 3, and Article 68. As reflected in the preamble to the Charter, the United Nations were guided, among others, by the motive to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations large and small. Preambular paragraph 3. Having declared their lofty motives, the United Nations granted respect for human rights the status of one of the fundamental purposes of the organization. The Charter sets out that the purpose of the United Nations will be, inter alia, to achieve international cooperation also in. The Charter sets out that the purpose of the United Nations will be, inter alia, to achieve international cooperation also in 22. Promoting and encouraging respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 1-3. More specific rules of conduct aimed at the accomplishment of these tasks are contained in 3 sets of provisions of the Charter, on international economic and social cooperation, Articles 55 and 56, on the international trusteeship system, Article 76, C, and on the functions and powers of the UN organs in this sphere, Article 13, 1b, Article 62-2, and 3, and Article 68. Of particular consequence is the first set of human rights provisions, which relates to international economic and social cooperation laid down in Chapter 9 of the Charter. Its Article 55 sets forth that with a view to the creation of conditions of stability and well-being which are necessary for peaceful and friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, the United Nations shall promote, inter alia, universal respect for, and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 55c. As a direct extension these provisions, Article 56 provides that all members pledge themselves to take joint and separate action in cooperation with the organization for the achievement of the purposes set forth in Article 55. As far as the second set of provisions is concerned, it was provided that one of the basic objectives of the International Trusteeship System, chapter of the Charter, will also be to encourage respect for human rights and for fundamental freedoms for all without distinction as to race, sex, language, or religion, and to encourage recognition of the interdependence of the people of the world, Article 76c. Within the third set of provisions, the Charter translated its objectives and role in the field of human rights into the functions and powers of number of UN organs. Thus, the General Assembly was assigned the tasks of initiating studies and making recommendations for the purpose, inter alia, of promoting international cooperation in the economic, social, cultural, educational, and health fields, and assisting in the realization of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 13b. Thus, the General Assembly was assigned the tasks of initiating studies and making recommendations for the purpose, inter alia, of promoting international cooperation in the economic, social, cultural, educational, and health fields, and assisting in the realization of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion, Article 13b. 23. Another principal organ of the United Nations, the Economic and Social Council, was entrusted in Article 62 with a function to make recommendations for the purposes of promoting respect for, and observance of, human rights and fundamental freedoms for all. Paragraph 2, and to prepare